Yes, Apurva, please start. The event is live now.
Knowledge is limitless. It will never have boundaries for people who always wish to know. It is acquired from anywhere and everywhere, like through books, peers, parents, institutions, etc. But most importantly, from the teachers and the experts. Similarly, such webinars are a great source to provide wisdom. Good morning, everyone. I, Apurva Agarwal, welcome all the faculties, HOD ma'am, our esteemed guests, and all the students to this webinar on Introduction to Arbitration and how is it catering interest in litigating lawyers. It gives me an immense pleasure to announce that we have our alumni as guests for today's webinar, that is Advocate Garima Sharma. Ma'am is currently the member of Delhi High Court Bar Association and Chartered Institute of Arbitrators. She is also a research assistant at Offices of Justice R.C. Lahoti, former Chief Justice of India. Ma'am has experience of work with some eminent companies like Khaitan and Khaitan, Singh and Associates, AZB and Partners, Singhania and Partners, and trust me, the list just goes on and on about her achievements. We are blessed to have you with us now. With this, I welcome Head of Law Department, Dr. Professor Pallavi Gupta, to bless us with her kind words and welcome our guest.
Thank you, Apurva. Dear students, participants, and above all, the speaker of the day. Namaste to all. Uh, Advocate Garima is the alumni of Abbas College. She is of 2015 batch. Garima, I welcome you on behalf of Jamtech School of Law. And it is our privilege, we can say it is our privilege that we are calling you and you are saying yes, we will interact with our students, your juniors over here. And definitely it is a nice day for our students to interact with you on a very important topic, that is the introduction of arbitration, how the lawyers will cater it. Of course, arbitration as a we can say alternate remedy for which is available to all, and this remedy is a very most effective remedy, setting the dispute among the people who are parties to the dispute. It does not require any lengthy procedure to go into the court, and it is not required to hire name fame lawyers for that. So it takes very less time to get resolve all this. So this is a very interesting or emerging topic for the lawyers to get it, and now you are here to introduce about this topic and the importance of this topic and how the lawyers will tackle it. The budding lawyers, the upper students of the first year, definitely they will be benefited. So I welcome Garima.
Thank you so much, ma'am. Thank you so much.
Over to Apurva.
Thank you so much, ma'am, for such a warm welcome. Now, without wasting much of our time, here I welcome Garima ma'am to finally start with the webinar.
Yes, am I audible? Can I start?
Yes, ma'am, you are audible.
Okay. So a very, very good morning to all my respected teachers, my junior, Miss Apurva Agarwal, and all the first year students to whom I'm going to address today. This is a privilege for me, first of all, that I've been called by my own college to address the budding lawyers who have just entered this field. So I am going to start with what arbitration is. So my purpose for introducing this topic to the first years was only one. There's my experience. From my experience, I can say, uh, when I started my first internship, I realized that the lawyers, the experienced lawyers, have started converting their way from litigation to other ADR mechanisms. As HOD ma'am rightly said, that people are converting to ADR, and we have not only one ADR mechanism, we have five ADR mechanisms. So before I start, in fact, during my session, I am gonna show a PowerPoint presentation along with which I'm gonna explain. So I'm gonna share my screen so that all of you can view this presentation. And one second, is everyone able to view this? Hello, can please someone help me out, Apurva?
Ma'am, we are able to see you, but not on your screen right now.
Can you
The
see my?
PowerPoint,
Hello, hello.
the PowerPoint presentation which you wish to show us, that is not visible to us.
It is visible. Great, that's great. Okay, so
Ma'am, it is
first
not
is
visible to us.
that's a technical glitch. I can't help it, but yes, please let me know when it is
I,
visible
I
because
would
I'm good.
I would just request if Trishima ma'am could help us in this, maybe.
Garima, means have you started screen sharing?
Yes, ma'am, I've started screen sharing. I've opened my document. One second, I'll try it again. It's okay. Yes, is it viewable now? Hello?
Not yet. Not yet. Not yet.
Not yet.
Dr. Shishma, please tell her how she has to go for live.
She has to just share the screen
I
and
have shared my screen, ma'am. There must be a technical glitch. I have shared my screen because I tried it, in fact. Just one second. There must be a technical glitch. I'll try it once more. Here, done. Now,
No, it's not.
no, still no.
No.
Anyway, that's it's okay. I'll just start speaking about it. So as Dr. Pallavi Gupta already said, that we have five ADR mechanisms. Ma'am told us about arbitration, and the other four mechanisms which we have is other is conciliation, third is mediation, fourth is lok adalats, and fifth is negotiation. I'm not gonna get into detail of every ADR mechanism because that would mean that I'm digressing from what arbitration is. So, without wasting any time, if I go further, uh, we, as being first year students, you must have studied what contract law is, what contracts are. When parties enter into a contract and form it becomes legal enforceability, they enter into a contract, and that's how that is the time when they say what an arbitration clause is, meaning thereby when two parties, for example A and B, they enter into a contract, they want to get into a commercial business they want to do. So during that business, involve one a very important clause, an arbitration clause, which is called, which means whenever a dispute arises between two parties, A and B, they go for arbitration, not litigation, but arbitration. Why? There are few reasons why will they go for arbitration. And there is a process why people go for arbitration. For example, a dispute arises between the parties. They invoke an arbitration clause. and that's when they appoint an arbitrator. Uh, yes.
Garima, if you won't mind, can you please that message that PPT to me? Can you share that PPT with me so that I can share the
Sure,
screen?
ma'am. Sure, ma'am. I think I don't know what is wrong with this right now, but yes, let's see. I'm trying to. I have sent to Rahul sir the PPT because I had this email ID.
Okay, okay, okay,
Will
fine,
that be
fine.
okay? Okay, okay. Yes. So can few participants be involved in it, because I really want to have a conversation with the first years. Is that possible? Hello.
Yes, Garima, they can text you. You can see their response here on your right hand side, I believe.
Okay. Okay. So
Okay,
I was
they
yes.
can interact with you.
Okay. So, as I was saying, when there are two parties who want to enter into a contract, they want to do a business with each other, they want to enter into a commercial business with each other, they enter into a contract in which they involve an arbitration clause. What an arbitration clause is that whenever a dispute arises between parties, they'll go for arbitration. The benefit being that they'll have their choice to choose the arbitrators. Whenever we go for court litigations, we don't have a choice to choose our judges. But in the arbitration, we do have a choice to choose our arbitrators. How it is done. For example, so there are two types. Besides this, there are two types. There can be a sole arbitrator, there can be an arbitral tribunal. Arbitral tribunal has three members of arbitrators. It has three members. One is nominated by one party, other is nominated by another party, and those two nominated arbitrators choose one arbitrating arbitrator. It's not like this presiding arbitrator has a bit higher authority. No one is less or more in this. But yes, a bit like 10-15% higher authority is held by presiding arbitrator, as he's chosen by the other two arbitrators. I hope I'm clear about it. If not, please message me about it. I'll, of course, answer your queries. So now, if people go for arbitrations, two question arises. Why not court? Why arbitrations? It's okay. I don't want to choose. That's such a headache. Why should I choose my arbitrators? Why should I choose my judges? There are two answers to this and two questions. Why arbitrations and what is arbitration? So one by one, I will answer. First, why arbitration? Next, what is arbitration? First, if I say what is arbitration, for the starters, as Pallavi ma'am said, it's an alternative dispute resolution mechanism. Alternative dispute resolution mechanism. From time immemorial, we know just one dispute resolution mechanism. Even I, being the first year student or just the new entrant in this profession, I also knew only one dispute resolution mechanism, that is courts: Delhi High Court, Supreme Court, District Court. That's it. I don't know anything else. But then I realized there are alternative disputes as well. What are alternative disputes? As I already told in the first 5 minutes of this lecture, that there are five alternative dispute mechanisms. I would repeat: first, arbitration, which we're talking; second, mediation; third, conciliation; lok adalats, and negotiations. So, if you're talking about arbitration, the arbitration is when an adjudication of dispute is done outside court, as we already talked about, as Pallavi ma'am also said, outside court, by an independent third party. Who is an independent third party? The arbitrator. Either it will be an arbitral tribunal consisting of 3 members of arbitrators or sole arbitrator. A sole arbitrator is chosen by the mutual consent of both the parties who are into dispute. It should be an independent person, impartial person. It shouldn't have a fiduciary relationship with just one party. I believe that being first year students, all of you must be knowing what a fiduciary relationship means. We have studied in contract law. So a fiduciary relation should be there with the parties, with both the parties. The sole arbitrator should have the fiduciary relationship with both the parties, not only one. That would actually prejudice the proceedings of the hearing. The other party will say, "What is this? Why is that? Why is the arbitrator being chosen by the person who is having such a relationship with the opposite party?" Of course, it will prejudice the proceedings. They will say, we'll lose the proceedings. That's a very human. That's a human nature. That's very simple understanding. Then arbitrators are chosen by the parties. As I already told, that arbitrators are chosen by the parties. It involves party autonomy. It is so convenient for the parties that whenever they enter into a dispute, they have to choose their own arbitrators. They don't have to go to court. They don't have to knock the doors of the court. Please take our case. Please resolve this. No, it's not done like this. But yes, subject to the situation when court himself chooses it. So there is one catchy thing in the party autonomy in this. Sometimes what happens is when parties decides, okay, we don't want to take a headache to choose our arbitrator. Let's go to court, file an application under Section 11. Section 11 of Arbitration Conciliation Act. There is a governing law for arbitration, that is Arbitration and Conciliation Act 1996. So under Section 8, the parties approach the court, they tell them the dispute and request them, please choose an arbitrator for us. Under Section 11, they appoint an arbitrator. An arbitrator is appointed. And they can usually, what I have seen in this profession and with my experience, I can say that the courts usually choose only one arbitrator, a sole arbitrator, and they say that the proceedings will be held by this person. And that arbitrator receives a letter from the court, and he has to abide by their decision. They have to go further with the proceedings. They can't deny it, because otherwise when an arbitrator is approached by a party, they have an opportunity and they have a choice. The arbitrators have a choice to, deny the proceedings, that I don't want to get involved in this proceeding by whatever reason they have. Next is adjudication or resolution is done within 1 or 2 years. This is the best thing I like about arbitration. We don't have this in litigation. For example, A and B enter into dispute. Let's take, there is a property dispute. They knock the doors of the court. One says that ये मेरी property है, other says ये मेरी property है. Now it goes for the next 10 years, 15 years, 20 years. We have heard this so many times. The case तो इतना लंबा चल गया. The parties, लोग मर गए. उनके जो बच्चे हैं, they are fighting the case. So this is not happening in arbitration. In arbitration, the case is decided in 1 or 2 years, max to max 2 years. 12 months to 16 months. And the marginal line, the basic line is 12 months. The matter should be ended in 12 months plus 6 months, that is 18 months. If not, that's possible. The parties talk with the arbitrators. They have a communication, they have a mutual consent. Okay, we think that the proceedings is going to take a bit more time, so we can seek for extension from the court, the relevant court, the court which is having a jurisdiction of that area. The relevant court, they approach the court, they file an application under Section 29A of Arbitration Act. They seek for extension of time. They grant them extension of time. You can't say that they can deny the application. They cannot. If the parties are approaching the court with mutual consent, both the parties are approaching the court, they won't deny it. They pass the application. It is an extension. It's on the mutual consent of the parties, but I can surely say not more than 2 years. An arbitration takes time. It's resolved. It's done and dusted. Next is the parties are permitted to agree upon the procedure to be followed for such arbitration. This is very interesting. How? We have 3 procedural laws, that is Code of Civil Procedure, Criminal Procedure Code, CRPC, which we say, and Indian Evidence Act. These 3 acts you will study later. The first years will study later, but you should know that these 3 acts actually goes along with a court proceeding. These 3 acts are there in the court proceeding. The only difference is, mind you, the only difference is that CRPC, that is Criminal Procedure Code, applies in the criminal matters which are before the court. Civil procedure, the CPC, applies in civil proceedings. It is very, very impliedly, explicitly stated. So these three provisions, these 3 bare acts, or the laws, or the procedures are not binding. Does not bind the arbitration proceedings. It's up to the arbitrator. It's up to it's up to the parties and the arbitrators if they feel like, okay, we can apply a bit of procedure. Usually civil procedure code is only applied in arbitration if the parties feel like. Nothing to be bound of. Koi binding nahi hoti hai whether it should be applied or not. But yes, in courts, of course, without this you cannot work. Your case will be rejected definitely. So please, the arbitration. So don't feel like this is not binding. So we can't bind in arbitration as well. But no, it's not like that. Next, so this is what is arbitration. This is basically an overview, and I believe the overview is enough for you to understand what an arbitration is. Next is why arbitration. The answer lies difference between litigation and arbitration. Till now I was just telling you a very, very brief difference between litigation and arbitration. But if I tell you point wise the difference between litigation and arbitration precisely, briefly, clearly, you will get a view why people are converting towards arbitration. First is procedure. I've already told, stringent procedure or in litigation, but flexible and controllable procedure in arbitration. There is flexibility in arbitration. There's a lot of flexibility in arbitration. The parties can decide with the obviously consent of the arbitrator the next date of hearing. The procedure can be decided with the mutual consent between the arbitrators and the parties. Next is time period. Of course, there is no time period specified to adjudicate the proceeding before the court of law. But there is a time period to decide the proceedings before arbitral tribunal. That is in arbitration. It's a speedy process, of course. Within 12 or 18 months, it's done. Then is the confidentiality issue. When 2 parties enter into a contract, that's a basic nature again. When 2 parties goes into a dispute, when they enter into a dispute, they don't want to disclose it. They don't want to let people know. We all are of the same mindset. Why should people know that I'm in a dispute in a court proceeding, or I'm in some legal proceedings? Please trust me, we as legal professionals are seen as a sin for the normal people, because they think, "Are yaar, fir se court ke dhakke." That happens a lot. People will actually see you as a sin. So they don't want people to know that we are in a court proceeding, we are in a legal proceeding, we are involved in a legal proceeding. That throws a very bad impression on normal people. That is a stigma, but we can't change it. So there is a privacy and confidentiality in arbitration. it's a closed door proceeding, arbitrator, two parties, and their learned advocates. That's it, and a stenographer, of course, to record the proceedings. That's it. No one else, no one knows until an award is passed. Okay, I won't mention the award thing. This will come later. Otherwise, you guys will get confused. So, privacy and confidentiality. Usually, there is an open court proceeding in litigation unless there is a very serious offense which involves a woman. For example, rape, of course. So that I hope all of you must be knowing that a proceeding which involves a victim of rape, a prosecutrix, that is a closed door proceedings. It does not party autonomy. As I have already told you people that it's up to the parties who decide their own arbitrators unless they approach the court, but that is also on their mutual consent. They want court to decide who this whole arbitrator would be or their arbitrator would be. That doesn't we don't get choice of choosing our judges in litigation. We go to judges on the nature and the roster. By roster, I mean that every year there is a new, after every 6 months there is a roster which is prepared by the collegium or by the chief justice, that these set of judges will handle these set of cases. These set of judges will handle such so and so cases. So we don't have a choice to choose our judges, but we do have a choice to choose our arbitrators. An order. Next is an order, decree, or judgment is passed in litigation. In arbitration, an award is passed. You can simply understand that a judgment, what we call judgment in litigation, we call award in arbitration. An award is part in arbitration. Never say that in arbitration proceedings judgment is part. No, that's a big no. That's not allowed. That's not a fact, and that's not legal. And I would like to invite few questions from the first years so that I could address them if in case there is a fact or a law which many of you are not able to understand, because I completely understand being first years, it will be a bit difficult for you all to understand what an arbitration is. So I would like to ask, what are your queries out of it? Because of some technical glitches in the starting, I actually was thinking, I don't know, I actually panicked in the first 5 minutes because of the technical glitches. But I really want to ask, what are your questions, your queries? I'm here to answer.
Ma'am, as I was reading some of the comments by the first year students, I read that there are some of the questions about the session. So should I read it out for you?
Of course, one by one.
Yes. The question first starts like this. If the parties are not ready for arbitration, then can another party force?
Can you please repeat, because your voice is echoing?
Yes, sure. If the parties are not ready for arbitration, then can another party force them?
I'll repeat your question so that I have a clarity that I'm correct. Please, I be corrected if I'm wrong. Can the arbitration not choose? Can the parties not choose arbitration and go to courts, right?
Actually, the person who asked this question intends to ask that if there are two parties in an arbitration, like of course there would be two parties, then if one of the party is not ready to opt for arbitration, then can another party force him or her?
The only remedy of such a situation is that one party goes to court and invoke their arbitration clause, because we all know how contracts are binding, correct? Contracts are binding on both the parties when they enter into a contract. If they don't abide by the contract, what will that be called? Breach of contract, because that's a part of contract. as I already told, that an arbitration clause is involved in a contract, and if that clause, usually this doesn't happen that one party deny that I don't want to go for arbitration. That doesn't happen because they know they are bound by the contract. They have to go for the contract, and they are in a mutual consent. But if in case that happens, one party can go to court. They can say that we were involved in an arbitration clause and we want to invoke an arbitration clause. Why can the other party say that no, arbitration cannot be invoked? That is not possible. And in practical circumstances, the court allows an arbitration, and the other person is to follow the orders of the court. I have the next question on screen, I guess. Can I file case against? Okay. Well, that's not my area to answer your questions. So, next question, please.
I think Garima, are you here? Hello. I think she
She lost
left.
the connection. She lost the connection again.
Okay. Apurva, do you have her number? Means, or Rahul sir, please connect with her.
I do have a number, ma'am. Should I contact you?
Hello, I'm sorry, I lost the internet. I'm really sorry.
It's okay, ma'am. We
Yes.
totally understand the technical issue. So, coming back to the question is difference between conciliation and arbitration.
Okay, that's a good question. That's a very, very good question. So, as I already told you, what an arbitration is. Arbitration, if I start with, uh, arbitration is that a dispute is getting resolved out of court, but it is not being settled. It is being adjudicated. It is being decided by both the parties, which has one arbitrators, and that decision is bound on the parties. It is equivalent to an order passed by the court. But in conciliation, it is an amicable, swift, and cost-efficient settlement. I can say, if I am not wrong, that's an amicable settlement. So there's a difference between a settlement and an adjudication. In settlement, there is a win-win situation. Both the parties win. They come to a conclusion which actually favors both the parties. But in arbitration, that's not a win-win situation. That is a win-lose situation in which one party wins and another party loses. So if I say that conciliation forms a settlement, but it is bound on the parties, but in arbitration it forms a decision which is bound on the parties. Yeah. So there's the only difference is the conciliation is about the settlement, but arbitration is about a decision, an award which is passed in favor of one party. But both bound the parties who are involved. No one can actually go against it unless they file for an appeal. Yes.
I don't see any more questions coming from first year students. So shall we continue with the session?
Sure. Sure. So if I continue with it, if I say that, as I actually told, actually this question reminded me of one aspect which I forgot to tell, that the settlement and adjudication aspect. I hope everyone knows that there is a difference between settlement and adjudication. If I talk about other ADR mechanisms, conciliation is one mechanism which is not opted much in profession, to be honest. It's not opted much. Arbitration is a lot in demand, a lot. Conciliation is one aspect which parties feel no. Why do conciliate? Because this would involve only two parties. There won't be any conciliator. There's no one person as in arbitration we have an arbitrator. Here conciliator are the two lawyers who are involved. Yes, and there's no third party in conciliation. There's no third party in conciliation. We just have a round table. The other one party and opposite is the another party. There is no middle person or impartial person to resolve that dispute. They have to do it within themselves. There's no impartial third party. Yeah, and in arbitration we do have. And if we go further in arbitration, if I talk about it, arbitration is very, very interesting in many aspects. Okay, I think I'm. Just 1 second, Apurva. I'm having some issue. Just 1 second.
Not a problem.
So I was saying why people are converting as the second part of arbitration. If I say why people are converting towards arbitration, I've already introduced what an arbitration is, what is it is all, why arbitration and what arbitration, but why already established practicing advocates are converting their route from court litigation to arbitration. Why? It's a very interesting reason. So parties who enter into contract, you can't say that an individual in arbitration usually it's not like I'm an individual, I am G, other is A. So I want to do, I am a sole proprietor, other one is also sole proprietor. We have a very, very basic business like a ration shop. I want them to deliver me something. we enter into a contract. Usually that doesn't happen, but we enter into a contract. If we see human aspect, people won't go for arbitration in this situation. That if any dispute arises, will they go for arbitration? No. Arbitration involves very, very big companies, very big companies. The dispute which is involved, you can say, is 1,000 crores or more than 1,000 crores, 5,000 crores, 10,000 crores. It can be of any. And you just say a number and you will see that amount. You can see that amount of dispute anywhere. Arbitration doesn't involve the basic amount of dispute. No, it involves a big amount of dispute. So I really wonder sometimes why parties, when enter into a contract, go for arbitration. There is one negative aspect for the parties, I must say, that when they go for arbitration, it's very, very expensive. It is expensive to some extent. The Because the parties have to bear the fee of their lawyers, the assisting counsels, the arbitrators, and for the proceedings, if the proceedings are being held offline, they'll have to decide the venue, they'll have to decide the place where the arbitration could be held, and that cost also, so they'll have to pay there as well. It is very expensive. And and the other aspect which I want to talk about is, when people enter into arbitration, they think that ठीक है जल्दी निपट जाएगा. It will actually be resolved as soon as possible. But there are some tactics when lawyers involved, which lawyers actually opt for in arbitrations. They go for next date of hearing, next date of hearing, next date of hearing. It is on the discretion of the arbitrators. They can grant them the time. It is the discretion of the arbitrators. And in courts, there is a limited extent to which the arbitrators, to which the parties can seek for other date of hearing, unless there is a very valid reason for it. Now coming to the types of arbitration. What types do we have for arbitration? In India, we follow two types of arbitration. First is ad hoc arbitration. Second is institutional arbitration. Ad hoc arbitration is what I told you, when the two parties choose their own arbitrators. That is ad hoc arbitration. Institutional arbitration is when they select an institution to decide their own proceedings. In ad hoc arbitration, what parties do? They decide their own proceedings. They decide how the proceedings will go by. If we opt for institutional arbitration, for example, we have Mumbai International Arbitration Center, MIAC, in Mumbai. They have their own procedure. If we go for institutional arbitration, it's not the headache of the parties to decide the proceedings. It's not the headache of the arbitrators to decide the proceedings. It is the headache of the institution to decide the proceedings. What else institutional arbitration can do? They decide the proceedings. They manage the funds of the proceedings. They do everything. They don't say, okay, today we can't, today we are not in a mood to do the arbitration, let's forget it. No. MIAC, for example, we have MIAC, but the best arbitration center or the hub is Singapore International Arbitration Center, SIAC, which is also called SIAC. If you want to opt for arbitration in future, please opt for NUS. Singapore is the hub of international arbitrations. So if you can study more about it if you want to. Of course, in third year, you'll study what arbitration is, and in much detail, and in your internships as well. The Singapore arbitration, in Singapore, arbitration is treated like anything. They don't go more for court proceedings, but they go for arbitrations. Now we have one more thing. This is ad hoc arbitration, institutional arbitration. Another is domestic arbitration, international arbitration. What is it? So there's a difference between domestic arbitration and international arbitration. Domestic arbitration involves that there are two parties, both are of same country. We have India, we have Indian jurisdiction. I am getting into a dispute with another party. I'm getting in dispute with A. I'm an Indian, he's an Indian. His company is an Indian originated company, a company which is incorporated under Indian Companies Act. I have a company which is incorporated under Indian Companies Act. We enter into a dispute. We can go for domestic arbitration. That is called domestic arbitration. What is international arbitration now? If even one party is of international origin, they are for example, just a paramateria. Uh, for example, A is an company incorporated under Singapore Companies Act. I may be wrong. They must not have their companies. This is just an example. They must not have their own Companies Act or Singapore Companies Act. I have no idea of their name, but yes, for example, hypothetically. So though that will be an international arbitration because that's a very logical that they are an international entity. I am an Indian entity. We are international arbitration, and we can go for a third party to resolve our disputes. It's a party's understanding if they want to keep an arbitrator of one particular origin. For example, it is a amicable conclusion of me and the Singapore company that we want to enter into an arbitration. We want to invoke our arbitration clause, and we'll choose the SIAC, Singapore Arbitration Center. That's my consent. I've given them my consent, but still that will be called an international arbitration, nothing else. What I believe is, that's my opinion, that if there are two countries, none of them should have their own origin arbitrator, that there should be a third origin arbitrator. For example, I and Singapore has entered into a dispute. We should go for a third country. For example, we want to go into London Arbitration Center because that will be a neutral party, third party. That's what my opinion is, but that's not usual course of people because that saves cost. If we go for one of the parties arbitration center, usually when people go into our international arbitration dispute, they go for an institutional arbitration, not ad hoc arbitration, because that saves a lot of time, that involves a lot of time. So it's good if we select only one arbitration center which can handle everything: the appointment of arbitrators, the fee of the arbitrators, the funds of the proceedings, and everything. Next is, what is the legal framework for arbitration in India? How are you going to study the arbitration? We have, as I already told, Arbitration and Conciliation Act 1996. The arbitration in our country is the first legal framework which was established in India was Arbitration Act 1940. After that, in 1996, Arbitration and Conciliation Act came into picture, which was more into form, I must say, more modeled, better than 1940 Act, because 1940 Act did not support in many aspects. 1996 Act actually considered a lot of things. For example, party autonomy, discretion of arbitrators, appointment of arbitrators, award passed by the arbitral tribunal, setting aside of that award by going to court to set aside the award. So what happens is, I'll just complete this, then I'll continue with the legal framework of arbitration. Whenever an award is passed, one party wins, one party loses, as I've already told. So usually when the party who loses, they can invoke section 34 of Arbitration Act, and go before the relevant jurisdiction court and list various aspects on the basis of which they say that this award is not legal. This cannot be said as an award. This doesn't involve. There can be various reasons. They are that it is against public policy, it is against fundamental policy, and so on and so forth. I don't want to get into detail in this of section 34 aspect. That this you can just consider that section 34 is the backbone of Arbitration Act, because party who loses, he can say, okay, we can invoke section 34, and the lawyers are so smart, they can give you 5-10 reasons why this award should not be enforceable. So they go for section 34. If the court is convinced, okay, right, correct, this award shouldn't be enforceable, they actually unenforce that award. They set aside that award. That's the correct word. They set aside that award. And against that set aside, an appeal can also be passed. So so I was talking about legal framework of arbitration. This is section 34. I just wanted to give you all a bit of idea of what section 34 is, because this is a very important provision in Arbitration Act. So yes, I was talking about 1996 Act. It also talked about conciliation, and most important thing, there is unilateral model laws which are set by the United Nations. It is the, what should I say? It is the base of the Arbitration Act. You can say that Arbitration Act is made on the basis of unilateral laws. Unilateral laws are followed by many countries of this world. Unilateral laws are, you can just have an idea, because I don't want to use a very heavy facts on it. This, you can just have an overview of arbitration. Yes. So yes, 1996 Act is based on unilateral laws. It involves conciliation. The act involves the provisions on conciliation and arbitration. There are two conventions, that is New York and Geneva. So in there is New York Convention and there is Geneva Convention. They have pit different arbitration resolution mechanisms. And after the 1996 Act, it was realized that there is a scope of improvement in the Act. Then in 2015, an amendment was passed in the Act. Many amendments, like there was an amendment in section 34 as well. There were insertions, there were deletions. The latest amendment is the 2019 amendment. It is still called Arbitration and Conciliation Amendment Act 1996, but the last amendment was in 2019. After 2019, if you are aware that recently Arbitration and Conciliation Act has again been amended, like last week. Before that, an ordinance was passed last year when the parliament was not in session. So when the parliament is not in session, an ordinance is passed by the center. And that ordinance changes the they can change the law or the provision. An ordinance is active till the time the parliament is sitting and passes that ordinance and makes it a law. So yes, the latest is 2020 amendment. I don't want to get into detail. This will confuse you all. This is I would definitely digress, because if I start with the amendments, I can take whole day, which I don't want to. And next is what are the important elements of arbitration? Firstly, there should be an existence of an agreement. So yes, I really hope and believe that all of you must know what is the difference between a contract and agreement. Every agreement can be a contract, but every contract cannot be an agreement. An agreement becomes a contract only when it is enforced by law. How is it enforced? It is enforced when there are two majority parties or competent parties with a consideration for a lawful object. So there must be an agreement or, of course, a contract to refer the dispute to arbitration. And here we of course had if there is a proper contract, there are two parties, there is a consideration, there is a lawful object, then of course it's a contract and in which arbitration clause involved. So it is correct. Next is arbitral tribunal must reach decision based on the facts, because the main object is to see who is right and who is wrong, who is legally and factually correct and who is not legally and factually correct. There is an adjudication, there must be an adjudication in this. The decision binds all the parties, enforceable as a court order. Should I continue or should I?
Please continue, ma'am.
Yes, I'll just take 5 more minutes and then I'll conclude.
Sure.
Yeah. There's a lot of noise, Apurva. Uh,
Yes, I guess someone's mic is switched on and they're not aware of it. Sushma ma'am, can you help us, please?
Yes, Apurva.
Ma'am, there is a lot of voice in the background. Has someone switched on its mic and is not aware of it?
I don't know. Only your, mine, and Garima, we are only unmuted. Else are muted.
Okay. I just switch off my mic. I don't think that the
Is it okay, Garima now?
yes, ma'am. Yes, ma'am. Thank you.
Okay.
So I think I've taken a lot of time. So I would just like to conclude by spelling out, to conclude the whole uh, uh, the last 1 hour, and tell you why what is the mindset of all the lawyers while shifting to arbitration. First, it doesn't take a lot of time. It is concluded within 1 or 2 years. That's it. That relieves the parties, that relieves the arbitrators, that relieves the lawyers who are involved in it. It is speedy. Flexibility and control, already talked about. So if we talk just one thing, if we talk about the cost involved in it, That depends on the parties, to be honest. It can be, it can involve high to highest cost. It can involve the basic cost. What I mean by the basic cost is there's one more thing which is important. It is by the mutual consent of the parties and the arbitrators. So it is up to the parties if they opt for fourth schedule, which is involved in Arbitration Act itself. The fourth schedule is about the fee of the arbitrators and how much fee are they going to pay to the arbitrators. It involves a stipulated amount. For example, what this is a basic amount. If there is if the amount is more than 2 crores, there is a stipulated amount that 49,50,000 rupees is going to be the fee of one arbitrator. If the amount in dispute is more than 2 crores, then the fee of the arbitrators can be of basic 49,50,000. That's what is written in fourth schedule. But that is up to the consent of the parties and the arbitrators. It's a discretion of them whether they opt for fourth schedule or for other proceedings, or for other amount, as will be decided by the arbitrators. Next is simplified rules of evidence and discovery. You can say, if we talk about the process of how the proceedings are held, in arbitration, we have the preliminary hearing. After preliminary hearing, there is there is a first hearing after preliminary hearing, which talks about how the proceedings are going to commence, how it is going to go, what are the points for determination in it, what are the issues involved. As you have been doing, at least you all have done your intra moot court at least once. If not, I'll let you know that it is very important to decide the issues in question, because without them, of course, you can't say who is gonna argue on what. So then there is the points for determination. Then there is cross examination. Either the party can produce affidavit on evidence, which is also called examination in chief, or they can actually give oral evidence in examination in chief. Usually in arbitration, people save time and they don't go for examination in chief, but just opt for affidavit and evidence. What is affidavit and evidence? That if I am the claimant, I have a witness, uh, I have to give his statement, affidavit of evidence, that what his case, what his part. So he'll draft an affidavit and will circulate it within the arbitrator and the opposite party, on the basis of which the cross examination is held of the witness by the opposite party's counsel. I hope I'm clear. If this is the process, how and this is the same process which is conducted in courts. Examination in chief, affidavit on evidence, which can be interchangeably done by the parties, and the cross examination. Both are done in both the proceedings, in court proceedings as well as in arbitration proceedings. After cross examination of my witness by the opposite counsel, the vice versa is done. It goes the other way around. The same thing. Then comes the arguments. What happens in arbitration is, it usually is opted by the arbitrators that they ask the learned counsel of both the parties to submit a written submission as well, while they give their oral submissions. Same thing. So, for example, I'm an arbitrator. I want to listen to the arguments of the people, but I want a text in my hand to see that they are speaking, because you can't have a presence of mind 24 hours or throughout the proceedings. The arguments goes on for 5-6 hours. So I want a text in my hand, the way they are saying. I want to look at my book, which have been submitted by them, and I want to mark something. I want to see, okay, this has been said by them. So this is what the written submissions are and oral submissions are. It goes together. It's better if they go together. After this, the proceedings comes to an end, oral submission or oral arguments along with written arguments are the main thing which actually helps you to win or lose the case. That is the practical aspect. You when you'll intern with an arbitrator or with the any lawyer or with any lawyer, and they are in arbitration, and if you're lucky enough, you'll be able to see the cross examination of the oral submission. You'll see this is how the arbitrators are gonna understand the case. This is when they are gonna decide who is gonna win, who is gonna lose. I am working with an arbitrator, so I can say that they understand, they actually decides the case when a person is arguing. Before that, there's no argument, there's only points for determination. There is cross examination, there's examination in chief, and then nothing. We are not getting the sides of what are they going to say. We are not getting them. Like, what is their case? They should tell us, no? So yes, oral submissions helps this a lot, and in filing, in making the award, written submissions helps a lot. So yes, this happens. This is the procedure. Very simple. Then an award is drafted. After oral submissions, an award is set to, an award is decided by the case is decided by way of an award, which is passed by the arbitrator within a very less span of time. Within 3 or 4 months, the arbitrator circulates the award. Then it's up to the parties whether they go for Section 34 or not. Then, of course, privacy and confidentiality, which is maintained in the arbitration proceedings. No one knows that what is going on. Like, there are very high, as I already stated, that there are very high amounts, huge amounts which are involved in this. The disputes are huge, are for huge amounts. So it's not very safe if people get to know that how huge amounts are involved in it, how कितना पैसा किसके पास है, ये कोई नहीं बताना चाहता. तो वो for that it's better that we have privacy and confidentiality. And the second last point is arbitrator selection. Of course, it's on the parties unless they decide to go to the court of law to decide an arbitrator for them. And next, finality. Finality is when an award is passed and it is bound as the same, and it has the same parameter of what a judgment is passed by the court. That's it. I hope you are able to understand what, at least you'll be able to understand the overview of arbitration. And when you go for internships in your second years and your lawyers would be working in arbitrations, you will understand at least, okay, this is going to happen, this is what is this. So I hope you have got an overview. If not, you can ask me any question. Thank you very much.
Thank you so much, Galan ma'am, for having such an informative session. Okay, as we are just running out of time, so I'll just put 2 questions in front of you that have been asked by the students. So the first question goes like, can you please explain the role of Lok Adalats?
Okay, Lok Adalats happen monthly. Lok Adalats happen on Sundays, for the starters. It happens on Sundays and usually approached by people who are of very niche level, very basic level. Like, it is accessible to everyone. Lok Adalats is the kindest thing which we have in our country. People don't have to take a time or appointment. Lok Adalats, like last Sunday only, we had Lok Adalat nearby my place. People who had some griefs, they can go to Lok Adalats. They can actually tell them their griefs. For example, a challan has been made against me for driving badly. So I'm not getting my slip. I'm not getting a date for paying my challan. So I can approach Lok Adalat. This is one of the redressal which you can have. I can approach Lok Adalat and tell them, okay, I had a challan, but I'm not getting a date on which I have to give my fee. So can you please help me out? They do it. They do it. Lok Adalats are very convenient, very accessible. Like a laborer who is not that capable and he cannot go to courts or appoint a lawyer for themselves. Lok Adalats don't need a lawyer for a party to represent them. Lok Adalat can hear a single person, a non-lawyer as well, their grief, and they can redress them very easily. So this is very, very, very kind, very gracious thing in our country. Yes. I have another question by Professor Naresh Kumar Behel, whether arbitration and conciliation is possibly in criminal matters. No, sir, not at all. Criminal matters, there is no ADR mechanism which will deal with criminal matters. There's a difference between right in rem and right in personam. Right in rem means for public interest. Right in personam means for personal interest. ADR mechanism is, you can say, a right in rem. A right in personam. Criminal matters are right in rem. Even the courts have said, and it's a very basic thing, if there's a matter which involves a criminal activity, no one else can decide it except courts. Yes. Or only civil matters or commercial disputes are involved in arbitration matters. And if I say mediation matters, uh, usually family matters, for example, I want to file a divorce suit against my husband. I go to court. Court are flooded with matters. They have lot of matters. They are not they are there for right in rem. Yes, they usually understand that right in rem for the public interest is more important than right in personam. That's why we are called alternative dispute resolution mechanism. We can actually lessen the burden of the courts. So what court says, if there is a divorce suit, then you can go for mediation, right? You can actually have a mediation proceedings. Even Delhi High Court has their own mediation center. They have their own mediation center, and there they can decide, okay, how many of you, I mean, of course, it will take time for the answers. All of you must be knowing about the Ayodhya dispute. If you were following the proceedings, Ayodhya proceedings, the Supreme Court sent the parties to mediation. They tried that the matter gets settled out of the court, not adjudicated, settled. But it was up to the parties. They decided, okay, we don't think we can settle. We need an adjudication, so we should go to court. We should go back to court. So yes, court understood it. After a few months, they said that we can't mediate. We tried to settle the matter, but we couldn't. So please now adjudicate. So then we had the judgment after that. So this was mediation. I had one more question on screen. I believe it was, what is the future of mediation in India? So the future of mediation in India is very bright. Mediation, as I already told, that mediation usually happens in family disputes, property dispute. For example, I am in a dispute. I want this house. I am in dispute, but there was no will of my father before he died. So there was no will, and there is a dispute between me and my brother, that who this house will be of. So we go to court. Court says, again, this is a family matter. We don't think we should spend time to adjudicate your dispute. You can go for mediation. So the court orders mediation. The court only says you go for mediation and decide and try to decide there. They send us, they pass an order that a mediation should be done on it, and the matter goes for mediation. Then they try for mediation. If this doesn't happen, then the learned counsel of both the parties can go back to court and tell them, sorry sir, mediation to nahi ho sakta, we want an adjudication again. So usually mediation happens in family matters, and you know it very well that we यहाँ कमी नहीं है family disputes की in our country. So it can happen very, very easily anywhere. Not only India, anywhere. Family disputes. It goes for mediation, and being a mediator, is very good. By like being a legal professional, I can tell you, being a person having an expertise in ADR mechanism, in any of the ADR mechanism, I would actually tell you after arbitration, mediation is the ADR mechanism which is having a bright future. Mediation for family matters and arbitration for commercial disputes. And I again repeat it, no criminal matter is decided in ADR mechanism. Criminal matters are only decided in courts. Civil disputes and which doesn't involve a criminal matter at all, and commercial disputes are for our ADR mechanisms. Yes. Next, please.
I guess we are just lacking short of time, so we won't be able to take much more of the questions. But okay, this is the last question for the session. That what are the authorities doing to increase awareness about ADR so that the workload of courts can be decreased?
Okay, that's a good question. So recently, as I was talking about 2019 amendment of Arbitration Conciliation Act, this was the one step. This was one of the step which actually took to make India the arbitration hub of the world. So in 2019, the amendment has been passed in which a Delhi arbitration, I don't remember the abbreviated form or the full form, but yes, Delhi is soon going to have its own arbitration center. Delhi used to have an arbitration center, but it's not it's not much in the picture. So a proper act has been passed to tell people that yes, we can become an arbitration hub, an international arbitration hub, because practically if we see in our country, no one chooses. As I already told you, that SIAC, Singapore Arbitration Center, is the best arbitration center in the world. After that, London Arbitration Center. These two arbitration centers are like expensive, of course, but very, very well, very organized, very nice. And it actually attracts so much people to their country, that advertises the country, you if you can say. So we were not in the picture. So 2019 act actually helped our country to get into the picture of this world and tell the world we can become an arbitration hub. This actually involves so much international image, you could say, international image, that okay, this is a reliable we all know how we see other countries, like foreign countries, but we want our country to be involved in it. So and now this is being held, center is being established in our country. An arbitration center is being established in our country. So you can imagine how much people will be involved in it, how much employment it will give. They will have their own panel of arbitrators. They will have their own staff. That would attract so much employment. And a panel of arbitrators, attraction from foreigners, people will opt for arbitration in our country. One more thing, as I'm talking about, I remember of one more thing. It's the discretion of the parties to decide what will be the seat of arbitration. I was telling you everything, but didn't tell you one basic thing which actually connected everything. That how people decide why SIAC will be the arbitration center, while London will be the arbitration center. It is the discretion of the parties. That is called seat of arbitration. If there is an international dispute, we have to decide which law will be involved. The Arbitration Conciliation Act 1996 is for India. If there is an international dispute, as I told you, international arbitration, the parties has to decide beforehand while they making the contract that what will be the seat of arbitration. Seat of arbitration means what law will be governed. Whether if there's a dispute between Singapore and India, if this Singapore Arbitration Act will be applicable or Indian Arbitration Act will be applicable. That is something which is decided mutually between the parties. So to attract that attention, to tell people that India is the arbitration center, to make India choice of seat of arbitration for the international stakeholders of arbitration. This amendment was passed. It will involve a lot of labor and it has a very, very bright future. This is one aspect. Mediation is already having its limelight for the past 5, 6, in fact, more than that years. Delhi has its own Delhi Mediation Center. Delhi, in fact, has a Delhi Arbitration Center as well. Delhi Arbitration Center, in which people actually approach. Usually, when they go to court, and they opt for civil litigation to decide the disputes, and the court says it can be handled by arbitration. You can approach the Delhi Arbitration Center, and they pass an order accordingly. So it's having a very bright future. Don't worry about it. It is having more future than litigation. We are usually being the first generation lawyer. In fact, I am also a first generation lawyer. I was very, very apprehensive that how will I survive in this litigation, in this field. Then then you have to understand, you have to be very practical about one thing. I'm digressing off the topic, and I'm willfully digressing from the topic and just giving all the first years advice. I'm an experienced person coming from first to fifth year. Decide your field. Decide your field according to what you think you can achieve. You have the talent, but you're a first generation lawyer. You are gonna have a lot of struggles, and being a female, you will have more struggles in this field. You will have. That's a very practical thing. You will have struggles. So I took arbitration. This is a bit safer, interesting, because it involves litigation. Because if I want to invoke 34, I am not convinced with the award, I can go to court. Your court thing is also done. So yes, it is having a very, very bright future. Don't worry about it. Yes, I that's it.
Thank you so much, ma'am. Okay, so let's continue with the ending of the session. At the end of every event, it is crucial to be thankful of everyone who made efforts to execute it. Hence, starting with, I thank Garima ma'am for providing us with so much of knowledge on the topic and making time for this webinar. I thank HOD ma'am who always encourage us to be a part of such webinars and help us gain the wisdom. I thank Dr. Richa Srivastav, Mr. Rahul Arora, who coordinated throughout the event and always bring the best series of webinars at our convenience. And then Shishima ma'am, who has always been the coordinator of technical team and always coordinate with us regarding the technical issues. Then last but not the least, the audience which we have. Thank you so much for joining us with this webinar, and thank you for the students who raised such an inquisitive questions. Thank you so much, everyone. And with this, we come to an end of this webinar. Thank you so much, everyone.
I would like to say something.
Yes,
Apurva.
sure.
Please give me 1 minute, right?
Sure.
Okay. Garima, really, it was very wonderful lecture, and it was more than what I expect from you. And of course, you are beginner in this field, but definitely you will prove in one day, and you will be proud of us. And you are very bright student. You were very bright student, and now you are very bright. And I would
Thank
like
you.
to announce that you are working under Honorable R.C. Lohati. So it is privilege for us as you are the very good student and doing work under him. Definitely, and I was reading the comment which students were giving in the live chat, and they are praising you. Although there are a number of the questions, but all the questions cannot be taken, but you answer very well. So once again, I would like to say that I will be happy in future if you interact with the students. Okay.
Thank you, ma'am. Thank you so much for calling. And I would just like to say, I feel really grateful and honored that my own professors has thought that I could be here for a session with all my juniors. I really thank Pallavi ma'am, Rahul sir, Richa ma'am. uh, it's a feeling I cannot even express. It's very, very, I mean, I'm really honored that I have been called because I have been here and I've been taught by these people. So yes, I am. Thank you so much. Thank you so much for calling, and I hope this was a fruitful session for all of you. Yes, there were some technical glitches. I must admit there was some technical glitch. I'm really apologize for that. I'll make sure that it doesn't happen again. But yes, thank you so much. Thank you so much. I tried my best that I gave at least an overview to the first year students, and yes, thank you so much. And
Garima, there was not only first year students, there were your seniors also. Not seniors,
oh,
but the student of the senior batches.
okay, that's
That is
good.
Baba
That's
was
good.
there, and the other seventh semester students, and some, law firm is also there. You just after the session, you just check the live threads over there.
Okay,
Okay.
okay. Thank you
Yeah.
so much, ma'am. Thank you so much.
Okay.
Thank you very
And
much, Garima,
yes,
and thank you very much, Pallavi ma'am, for giving us this opportunity to give thanks on behalf of the institute also. And I would also thank Ms. Apurva Agarwal for moderating this interactive session with us. Thank you very much, all of you.
Thank you
And
so
I
much.
would like
thank
to
you.
thank
Thank
all
you
of
so
you
much.
for being here with us here today. Thank you very much.
Thank you so much. Thank you.
Yeah.
Thank you. Can I lead the meeting?
Yes.
Yes, ma'am.